Welcome to My Business Matters, the Michigan Chamber podcast.
Hi there, I'm Wendy Block, Senior Vice President of Business Advocacy for the Michigan Chamber and today's podcast host. We're going to be kicking things off today with a three-part series, Restoring Balance, Michigan's Case for Legal Reform. We'll be taking a closer look at how Michigan's legal climate impacts job creators, innovation, and the cost of doing business in our state, as well as our families and communities. We're going to start today with Sherman, or Tiger, Joyce, President of the American Tort Reform Association, and he's going to help us unpack what makes a fair and balanced legal system and why Michigan has fallen behind. We've got a lot to cover, so we're going to get things started. First of all, welcome, Tiger.
Wendy, thank you. Thanks for having me. Delighted to be on with you.
Yeah, delighted to have you. For listeners who might not be familiar with what we mean when we talk about legal reform and who's ATRA, can you tell us a little bit more about how we frame that term and how ATRA came to be and what you do?
Sure. Thank you. Well, again, thanks for having me on. Just for those who are not quite as familiar, we focus on broad-based, we at the American Tort Reform Association, civil litigation. And, just at the most basic level, we have the criminal justice system you're familiar with, sort of high-profile matters. But the bulk of our legal system really deals with civil litigation. These are disputes. They can be contract disputes. They can be personal injury cases. Any number of matters, and ensuring that the system works in a way that serves the interest of both those bringing cases as well as those who have to defend themselves is really an important issue, for everybody, whether, no matter what your circumstances are. So the American Tort Reform Association is really a broad-based coalition that's been around for nearly 40 years now. Next year will actually be our 40th anniversary. And one of the unique distinctions about ATRA is who we are. We are any number of businesses. We've worked with the Michigan Chamber for decades, and you've been a great ally and supporter and really one of the great advocates for legal reform. But our membership and support base includes healthcare providers, small businesses, service providers, major manufacturers. Here you are in Michigan, the auto industry is a great example. It's been a big supporter of the legal reform community. But really, to think of it, it's sort of all the distinct elements of our economy together that have a uniform or sort of a common interest in having the system work in a way that's fair, and doesn't take too long. One of the major criticisms of civil litigation is that the process takes way too long. So we've been working for many years to bring about and establish a balanced agenda of reforms and look to work with in-state allies like the Chamber to get them accomplished in their individual states, because this mostly is an issue of state law. For almost exclusively the issues that we focus on are state laws, not federal laws.
Yeah. So when we think about this issue, we often think, well, this impacts me if I'm in a lawsuit, right? But it really is much more than that. Can you help our listeners break down how they, whether they're employers, workers, consumers, how they are impacted by these issues on a daily basis?
Yeah, I think probably one of the biggest challenges on our issue is to both define some of the problems, but also to help the average person, whether it's just anybody, man or woman walking outside on the sidewalk outside my office, or whether in Lansing or anywhere in the country, that the abuses of the system, and unfortunately there are far too many abuses of the system, ultimately are paid by the consumers, by all of us as individual consumers. We estimate across the country that there is what we call a tort tax of well over $5,000 a year for an individual family of four. And these are not costs that you don't get an invoice, you don't get a bill. It's not a tax like you have taxes withheld from your paycheck. But these are costs that go into making everything that we use and consume or have to utilize much more expensive. Mm-hmm. And so it is a real cost. And the excesses and the abuses of the system also result in the losses of hundreds of thousands of jobs across the country on an annual basis. So the impact is real. Just helping to make that clear to most people, because I think, Wendy, you made a very important point. Most people think that maybe they're in a lawsuit, or they look at this issue and they think, well, that's for lawyers and judges and professors, people who've been to law school to deal with, and that there is an element to that. But the bottom line is that it is an issue that impacts all of us.
Yeah, whether you may see it or not, right? It's this hidden thing that exists and is passed on and paid for by all of us. So let's shift gears a little bit. ATRA releases an annual report that is quite catchy. It's called the Judicial Hellholes Report. And I guess I'm just hoping you can tell us a little bit about how this report came to be, what factors lead to this kind of designation, and what does it mean in terms of practical terms, in terms of how it can affect economic growth, things like business investment in a state or job creation investment, or even product availability and insurance costs. Just kind of help us unpack that a little bit more.
Sure, happy to do that. But before I talk about your state, let me give an illustration of where something we were just talking about, which I think also kind of helps illustrate what we try to accomplish with the Hellholes Report. A number of years ago, we actually had the state of Florida as the number one judicial hellhole, and the reason we do it is to highlight problems, mm-hmm. to put a bright spotlight on what we see as both the underlying issues, but also the places where we think litigation doesn't work properly, that it's out of balance. A couple of years ago, now 2023, you had Governor DeSantis and legislative leaders in Florida enacted significant reform legislation, and there was a lot of debate. It was a very difficult issue. It gets a lot of, brings out a very, very significant opposition from the personal injury bar. But the impact we're now starting to see is really affecting consumers. So you had in 2023 the enactment of this reform package, and just in the last few weeks we've seen, from the standpoint of insurance costs for Florida consumers, Progressive Insurance announced that it was issuing rebates of $1 billion. Wow. With a B. Now, it's a big state, but that's a lot of money, and one of the largest insurers in Florida, State Farm, has announced a 10% insurance premium rollback. So that's a pretty significant issue when you look at this question. But going back to the Hellholes Report, our purpose really is to try to highlight what we see as the most challenging jurisdictions, places where we think that the litigation system is not working properly, and we want this to serve as really, as I said, put a spotlight on it. And I think if you look at our report, we highlight the fact that the costs I think in your state are very significant. We saw that over 40,000 jobs are lost per year, and in terms of advertising, what you see on TV. I know I'm here in Washington D.C. We've been getting a lot of advertisements because of the Virginia gubernatorial race. But, tens of millions of dollars are spent on advertising. Mm-hmm. But the hope for, and again, I go back to Florida, is that by putting that spotlight on the problems, that it will serve as a catalyst, will help to highlight the issues. We want elected officials and leaders in the business community like you and your chamber colleagues, to equip you with rationale and an impetus to try to improve the civil justice system.
Yeah. So when people hear that word, they hear improve the civil justice system or pass legal reform, they may immediately jump to the fact that we're trying to limit legitimate claims or deny justice. How do you address that misconception? Can you explain the balance between access to civil justice and preventing abuse?
Yeah, I think that, there are policy judgments that go into all of that, but none of what we propose and what's been enacted in your state previously has ever done anything to limit the availability of recourse. Mm-hmm. I think that, important reforms help to clarify what the law is and what should be permitted. So, for example, one of the changes actually that your state Supreme Court made was it adopted the new federal rules on expert evidence. Expert evidence is an important part in some complicated litigation where you've got engineers and scientists and doctors helping to clarify for judges, for jurors, what technical issues really mean mm-hmm. and what's reasonable. Because, otherwise you could have, individuals sitting in juries having to decide, which of these particular experts, has the appropriate scientific perspective or technical expertise. We think that having judges police that process, ensuring that only good science, properly vetted and researched, peer-reviewed science and technical issues go to juries is a very, very important reform. To suggest that something like that is somehow limiting access to the courts, I think, is simply not true. Yeah. The bottom line is that our courts are open for all of us to use. One of the problems that we see is that we've got judges and legislators too often willing to allow cases that don't belong in a given state. Our friends in Illinois just passed a statute that's going to throw the doors open to litigation that has no bearing or no involvement with anybody or anything in Illinois. I think the courts in Illinois, the courts in Michigan should exist to serve the interests of the citizens of your respective states, not become, we call, a litigation tourism hub. Right. Which is unfortunately what we see in a lot of places. We're seeing it more and more places.
Yeah. So back to the judicial hellholes report. Michigan has appeared on the watch list as being a judicial hellhole. Really, the hellhole report has flagged some cases that have come out of the Michigan Supreme Court. So we've unfortunately stood out and become a bit of an outlier. But you also talked about states that have really been more proactive in this regard. What lessons can we learn from states that have successfully improved their legal climate over the last several years? And is there a state that we should be looking to as a beacon of success?
Yeah, I think so. That's a great question, Wendy. I think if I were to point out two states right now that have had success, I mentioned Florida. The enactments in Florida were in direct response to a lot of the issues that we had highlighted in our Hellholes report. Consumers and businesses in Florida were having a very difficult time with litigation-related matters. Florida's unique in the sense of its exposure for homeowners and businesses in terms of the
weather,
subject to the weather, exactly, and that's a unique challenge. But what I would also mention Georgia this past year. Georgia enacted a sweeping series of issues. Again, Georgia was the number one judicial hellhole. Again, many of the issues that we highlighted, I think, were addressed or there were significant efforts to address them in the reform package that was enacted earlier, I guess, this spring. But there's one common theme that I would point to from the standpoint of how to accomplish the reform efforts. Actually, I would say there were a couple. The first is you had gubernatorial leadership as well as significant legislative leadership. This is a difficult issue. The trial bar spends, is a single-minded, focused, and very effective advocates, and they're quite generous, as I think we can highlight around the country in the political arena. They are a formidable opponent when it comes to trying to move significant legal reforms. And finding the opportunity requires a lot of different steps, but I think it really begins with gubernatorial leadership. And as I said, we had great leadership in both Florida and Georgia in the state legislatures. I think, Wendy, we're going to see you shortly in a conference, a NATRA conference, and Senator John Kennedy was the President Pro Tem of the Georgia Senate. He's a great ally, an excellent lawyer, and he was a true leader in the legislative process. So I think it begins there. But then I would say that you need to have the reform community, a dedicated legal reform organization. The chamber has handled that role exceedingly well for a number of years, and I know we've talked about the new organization that's now underway in Michigan. Having that single-minded focus, developing a responsive agenda, and being actively engaged in the legislative process, I think, is where it all begins, and recognizing that it's a very, very significant challenge. But I would point to both Georgia and Florida in the last couple of years as excellent examples to follow.
Okay, great. And what, as time runs out here, what do you think, based on what you've seen in Florida and Georgia and other states, because you're involved in monitoring what's happening in all 50 states, I presume, what's one thing you think a state like Michigan can or should do to make meaningful improvement to its legal climate?
Well, I would say a few things. Number one, you mentioned, Wendy, that we highlighted some issues in your coming from your state Supreme Court. I think that addressing specific problems, whether it's dealing with premises liability, the expansion of finding new ways to sue in the employment area, I mean, I think you want to address those particular matters. Expert evidence, again, is another one. Those are out there. I think that legislative responses to those efforts, is important. If the court takes a position and articulates a perspective on a legal matter, it's perfectly appropriate for the legislature to recognize that that is the law, respect it, but responding to it. I would say if there's a single issue beyond that, let me take a little bit of a step back. On the legislative side, preserving the gains. Your state has a very enviable record of enacting reforms going back decades.
Right.
And I think our perspective always is, let's protect the gains of the past. Let's make sure. Now, you did, the legislature a couple of years ago overturned a provision dealing with government standards defense as a basis for indicating that liability isn't automatic in certain instances. So I think it would be useful to take that up. But if there's a single issue that I think we're seeing around the country, is we refer to it as phantom damages. I think for the average person, it's sort of hard to get a handle on the notion that, what is something, if you are injured, what is the actual cost of your medical care? Is it what, if you have private health insurance, is it the amount that your health insurance company paid to resolve a medical matter? We do sometimes see these abusive cases that have turned into widespread abuse when instead of filing medical claims with insurers, we call letters of protection, and that process where wildly inflated medical claims, become a significant abuse. So Florida and Georgia have enacted significant reforms. We've seen it in a few other states. From our perspective, it's a very basic matter, but beyond defending the hard-fought gains of the past, I would say that would be the best place to begin looking beyond the specific matters, additional matters that we highlighted in the Hellholes report.
Yeah. Well, Tiger, your wisdom has been great today, and I really appreciate your time. And a very special thank you for joining us for our legal reform series, and to you all for listening. Be sure to catch up part 2, where we talk about critical new statewide alliance and efforts to restore balance and predictability in our legal policies and courts. Subscribe or like our podcast for easy notifications. Until then.